All right, so we will get started at the stroke of two. People who know the Council on Women and Girls know that we always get started on time. So welcome, everyone, and we are about to start. All right. Thank you so much and good afternoon, everyone. We appreciate your joining us for this very important panel discussion on the judicial branch's pathways process for divorce, custody, and visitation cases. And I'm honored to moderate today's discussion. And I don't know why we're having feedback. Did we get rid of that? Fabulous. I'm honored to be here with some very distinguished professionals who represent various facets of our judicial branch, our legal community, and our advocacy organizations. In 2021, our state embarked on a journey in its approach to family law cases, particularly those that involved custody, visitation, and dissolution of marriage and legal separation. And this was a transformative initiative known as the Pathways Process to mark a shift in how people navigate through the complexities of these difficult situations in our court system. Pathways is aiming to ensure that every case receives the right level of court resources that it needs, and that the procedures are streamlined, and that we minimize the need for multiple court appearances. This process underscores our dedication to fostering resolutions and reducing the adversarial nature of the process. And so today we have some very distinguished panelists who are going to talk about the pathways process and give their insight and their expertise. And hopefully we will all have a better understanding of how effective that process has been. And I'm delighted to introduce our panelists. So we have with us Judge Michael Albis. We have Judge Leo Diana. We have Director of Family Services, Joe DiTunno. We have CCADV President and CEO, Meghan Scanlon. And we have Managing Attorney, Hartford Legal Aid, Enelsa Diaz, and Staff Attorney for the New Haven Legal Assistance Association, Margot Kenefick Burkle. So we welcome each of our panelists, and we're going to get right into it. So we're going to start with Judge Albis. And here is what we would like to talk about with you. Since you've played a very central role in developing the pathways process and you've been involved in implementing it, can you share some of the context for what drove the need to create this process and how the process is meant to address the issues that brought us to it?
I'd be happy to, and thank you for this opportunity, Lieutenant Governor, to be on this panel. I think before I describe pathways, I should talk about what the process was like before pathways. And this will be an oversimplified version just in the interest of time. And I'll talk about a typical divorce case, but the procedure wasn't much different for custody or visitation cases. So prior to pathways, when a new divorce case was filed, the court would set a date about 90 days, a little more than 90 days after the start of the case. That would be the first court date the court established. In the meantime, either party could file motions for temporary orders on matters like child support, visitation, alimony, household expenses, use of the family home, and the like. And if they filed a motion, every time a motion was filed, it automatically went on to what we called the short calendar, typically 2 to 3 weeks after the motion was filed. And every new motion got a new date on the short calendar. So cases ran from one extreme to the other. In some cases, often parties without attorneys wouldn't really know what to do after they filed the case. They wouldn't do really anything until their first court date came several months after the case was filed. So nothing really was being accomplished during that time. And at the other extreme, there were parties who immediately began filing motion after motion, coming to court time after time. And a typical short calendar, and I'll use Hartford as an example. That's where I started in family court. That's where Judge Diana is now. Every motion would get scheduled for the same day and the same time. So on a Monday morning, you'd take the bench at 9:30 or 10 o'clock. There'd be a packed courtroom of parties and attorneys. There might have been 100 cases on the short calendar when it was posted. Maybe some of those didn't bother to appear and told the court they weren't coming, but there'd still be dozens and dozens of cases to have one temporary motion or another heard that day. So the process would be that after some introductory comments, the judge would send everyone to go see Family Services, someone on Joe DiTunno's staff, to see if that particular motion could get resolved by an agreement that day, because obviously there wasn't going to be time for the court to have a hearing, an actual contested hearing on every single motion. You're lucky if in an average case, if you got 5 minutes of court time. Family Services did a great job of getting people to agree on their motion. Those who couldn't agree often just had their case postponed to another day when there was more time. If they only needed a very short hearing, they could get it on the short calendar day. Often, not often, but sometimes at the end of the day, we just ran out of time, especially in Hartford. And I can remember a couple of occasions where it was 5 o'clock and I had to tell people who had been sitting there all day, I'm sorry, we don't have time for you. You have to come back next week. It was a confusing process, especially for those who don't have attorneys. The attorneys knew how to negotiate their way around the calendar and how to get there early and who to talk to and how to get before the judge and get out. But most people don't have attorneys. They didn't know how it worked. They were sort of bewildered with all this activity. And in the best case, you would resolve one little piece of a temporary set of orders on a case and then wait for the next motion to be filed and then do it all over again. So we were concerned about that. In 2015, we got the results of a survey the judicial branch had commissioned about litigant satisfaction with family court. And actually the results were quite good. But the biggest area of complaint was the length of time it took a case to be over and the length of time spent in court on a given day. And both of those things were directly related to short calendar process. And the reason is that months would go by and people could come time after time on short calendar, and there was never time to take a look at their whole case and see what the case needed. We were always trying to patch up a particular temporary issue. That's all we had time for. And eventually, after several months of seeing the same people, you'd realize, hey, they need some extra help. Maybe they had a custody issue that needed an evaluation by Family Services, for example. Maybe they had a complicated financial issue that could use a pre-trial settlement conference with a judge. But we wouldn't be able to figure that out for months. So with the results of that survey, we started looking at the short calendar. We were assisted by the National Center for State Courts, which is a nonprofit group that gives advice and resources to state courts. They came and watched our short calendar in person, and they found it quite interesting and unlike anything anybody did anywhere else. And they started helping us to work on a better way to do this. And in the meantime, there were national efforts to review the family court process. And the National Center for State Court was part of that. And a report called the Family Justice Initiative came out as we were looking at our own process that gave the results of research from across the country and recommended two main features for a good family court process. One, what they called triage, which was to get the case in early, analyze it, see what resources it needed to be resolved, anywhere from some minor negotiation to a full-blown trial, and to try to identify the cases early. And then, once you've identified the cases, to put them on the appropriate track to resolution, not to send everyone through the same process like we did before, but to take the cases that could be resolved quickly and get them resolved quickly and let those people go on with their lives. Find the cases that needed a lot more help, like an evaluation of some kind, and start that early, not wait until the case was almost a year old before you realized you needed an evaluation that would take several more months. So that report came out, and then the Council of State Supreme Court Chief Justices followed with their recommendations that all states do this. And we got a lot of guidance and information from those sources. At the same time, we were concerned about domestic violence in family matters. And we realized, first of all, the need to identify that as an issue early on in the case, which was hard to do under the old process when people were coming in for these short, limited issue matters, as opposed to looking at the case closely in the beginning. And we were also concerned about litigation abuse. And I was invited to participate in a forum that Senator May Flexer had back in 2019 as we were working on developing pathways. And it really brought home to me how an abusive partner could use the process to make the other party come to court repeatedly, keep taking time off from work, maybe eventually risk a job, have to arrange for childcare on short notice because you don't get a lot of notice of the short calendar. And that really brought home to me that, among other things, we had the short calendar was the perfect tool for an abuser like that. All they had to do was file a motion, they got a court date. And we decided that it was imperative that the court take more control over the scheduling and have people come in less frequently, but when we had time for them. So the outgrowth of all this was the pathways process. And I'll just give you the main features, because I don't want to monopolize the time here, but I think the most important feature of pathways is the early triage. In every divorce case now, instead of waiting 90 days and letting the case fester for months, just to come in for a brief time on a court date with a bunch of other cases, we have what we call a resolution plan date that should be 30 to 45 days after the case is filed, to give people time, especially if they're the defendant, to get an attorney, to gather some information. But we bring them in early, and they begin with a fairly intensive meeting with a family relations counselor, and Joel will talk more about what they do, to try to identify the issues in the case, to see how difficult the case might be to resolve. And then they get orders from a judge. They go before a judge to get a scheduling order, to order services that might be needed in the case, and to set one or more case dates, which are preset dates where the parties know they can have their temporary motions heard. They're not going to have to come to court every time somebody files one. They have this date, maybe 30 to 60 days away, which will be the day for having motions heard, among other things, and checking on the status of the case. If there's a more urgent motion that shouldn't wait that long, we have what we call a motion docket, where if there is a particular issue that needs attention more quickly, the parties can ask that it be placed on a motion docket, which is more like a short calendar, except not loaded with so many cases that we can't hear them. In the more complex cases, the idea is to designate a particular judge to be the judge to handle that case from start to finish, a family relations counselor to be the dedicated counselor for that case, and to get resources and a trial date set earlier rather than later so that the parties know when the matter is over. We implemented this during the pandemic, which was very difficult and not the ideal way to do it. And there were a lot of bumps in the road. But once we began to be able to do most things in person, back in court the way it was intended. It has worked very well. And we can talk later about some stats. I don't want to take up more time, but that's an overview of why we came to do pathways and the skeleton of what the plan is and what it's intended to do.
Thank you so much, Judge Albis. So, Judge Diana, we'll go to you. You have been in your current role as Chief Administrative Judge for Family Matters for a few months, so I know you're all up to speed. So we're going to ask you, in this role, how are judges doing with this new process? And second part of the question is, do you think there is more need for education, both for judges and the parties, the litigants, lawyers, and others to ensure that the pathway process is correctly used?
Thank you, Lieutenant Governor. Good afternoon, everyone. Judges have responded very well to pathways. I like to say that pathways is a tailor-made suit instead of a one-size-fits-all. And if you think of it that way, it makes a lot of sense. Most family judges are unfamiliar with the old system that's called short calendar. So this is really the only process that they know in how to handle cases. Judges have received training on pathways from its inception in 2020. New judges have a 4-week pre-bench orientation, and part of that is dedicated to pathways, domestic violence, intimate partner violence, effects of domestic violence on children, victims' rights, and more. Mentors are assigned to all new judges. These are senior judges, so if someone's assigned to family, they have a family judge who is a mentor who they can consult with regarding any issues that come up. And there's a lot of issues that come up regarding these types of cases. We have an annual family division fall program, and we dedicate part of that program to pathways. We also have an annual Connecticut Judges Institute in the summer, and there's programs available regarding pathways programs. Family judges are also very social, and we have dinners randomly with all family judges are invited. Several, there's over 20 judges that come to these dinners, and we discuss pathways and other issues that we encounter in the family court. Family judges also have a domestic violence handbook. All judges have this on their computer to deal with all issues related that's immediately accessible to them. And it's substantive and a thorough information regarding all types of domestic violence and related topics and issues. So overall, Pathways has been, I think, very successful. Every court is a little bit different. Hartford is where I sit. Hartford is the busiest family court in the state by far. Then you have New Haven and Bridgeport. So it operates much differently than a court like in Tolland. Even New Britain is smaller. So, and the numbers are different because of how many family relations officers you have, how many cases come through the door, and what the schedules are. Because family court has these. In Hartford, we have 1 day is dedicated to this motion docket that Judge Albis referred to, and that's for more immediate things. So parties can file something with the court. There's a new statute that's been passed, and there's actually 2 ways to get on it. They can file under the statute, or they can file what's called a case flow request, which is a request that goes to the case flow coordinator. And think of that's a person in between the judge and the parties. The judge is that information is taken to a judge immediately and acted upon. And if the court looks at the case and determines that it should be placed on a motion doc for the reasons that are stated, then it's assigned to the motion docket, and that's fairly quick. What this does is in the last year, 2022, and Joe will go through some of these statistics, but I wanted to hit this one. 46% of all the cases that are filed are resolved in the first 90 days. So what that does is it takes the cases, because some cases don't have a dispute. They just want to get through the system. They've been separated for a long time. They know what they want to do. They just don't know exactly how to do it. So they're resolved in the first 90 days, and that frees up time for the court and for family relations services to be available for the other cases. Now, 90% of all the cases filed are resolved in 1 year. And what Judge Albis said about these comprehensive evaluations, which are fully contested custody cases, in the old system, you didn't even know about that until many, many months into the case. So it really would drag the case on when people are stuck in this really terrible situation and they don't see the end. What Pathways does is it puts the path of the case, it sets it up right away. And when lawyers are involved, they can help with the scheduling of all this. But 70% of the cases are self-rep individuals. So they don't understand pathways. And so they're explained pathways because the first contact that they make with court is with family relations at this RPD, resolution plan date. The process is explained, and this triage process is recommended by the family relations officer, and that information is given to a court. And then they see a court, and then their case is set on this path. And the path is different dates are set. A case date is set. A trial date could be set. Some cases don't need to have a trial. If it's a full contested case, it gets a trial date. Pre-trials are set, status conferences are set. So every case is tracked tenfold. There's no cases that slip through the cracks. And what it does is it allows the court to control the docket. And that was a really big issue about why the old system didn't work well, or it worked well if you want litigation abuse. It was fraught with that. And this attempts to resolve that. And I think it does resolve that. You've asked about the need for education on pathways to make sure it's correctly utilized. Yes, there's always a need to educate all the actors regarding pathways. We call them stakeholders, because pathways is new, because it's not a new system. But just think about it. Cases get processed. We have 4,000 divorce cases in Connecticut. Some people resolve their case and their case is over, but the next day somebody else is going to be filing a divorce. So this whole thing is new to them. So that's why you need to continue to re-educate. Self-represented parties have access to the judicial website, which explains the whole process. It's a very, very comprehensive explanation of the pathways process, but everyone doesn't have a computer. So in our courts, every family court has a court service center, and it's a room that has a live individual, that has forms, every type of form you can imagine, that explains the process. So it's a live person. It's not a tape. There's also victims advocates there. There's also legal aid there to help people with TROs. And so other than meeting with family relations to explain it, they can meet with the people at the court service center to explain it. There's paperwork in there so they can read something that explains it. And then when they have this RPD, they're in front of a judge. And if they're in front of a judge and they're two self-represented individuals, a brief explanation of what the next steps are is explained, because a judge doesn't just take the information from family relations, even though it's good information. And I might not agree with that track. After asking questions and based on the responses that I receive, I may decide that it needs another track. Or they may tell me, hey, we have everything agreed to, but this one issue. And sometimes they're, not really complicated issues, but they're a dispute, or it could be someone wants a deviation from the guidelines and someone doesn't. And I say, if that's the only issue that you have, would you like to argue that in front of me now? If I have your financial affidavits and all the other paperwork, and we're able to, a lot of people say, yes, I'd like you to do this because I don't want to have to take another day off from work. I don't want to have to find out where my kids can go to daycare. I don't want to have to worry about how I'm going to get here and how long I'm going to be here. If you can, hear us right now and it's going to take 15 minutes to do it. And so that's what we do at the RPD date. And that's why the numbers are so good. 46% of cases are resolved within the first 90 days. It's better than any other system. So I just want to say that attorneys being educated about pathways, they have other resources through their own bar associations, through the Connecticut bar associations. They have meetings and they invite the family judges to attend and they ask us questions, and we have our own forums with them. The last one that we attended last year, 13 family judges came. Judge Albis and I used to go to the other ones years ago. 5 or 6 family judges would come. I mean, they're very nice events. 13 judges came. So everyone is a little bit more engaged with this process. And as I said, the cases are all tracked. Judges get to see on their screens. There's something called the dashboard where we can see in our own jurisdictions and we can see the overall rate of all these cases. I don't want to say it's a competition, kind of a competition. It's, you know, you want to keep cases moving and make sure that the focus of the resources is given where it's needed. And parties and attorneys have access to the case flow coordinators, and that's kind of the key, and they might not know that. So that's why we always refer to them to, you know, see the case flow coordinator so that sometimes they file things, they want to move their date up. And if we can accommodate them, we do. Sometimes they want to continue their case, or sometimes they've resolved the issue and they don't need it. So it's a constant flow of information. The case flow coordinator in Hartford, just to give you an example, gets about 100 emails through this a day, moving cases. So, and I have attended the case flow coordinators meeting. They're all very tuned into pathways. They, you know, take pride in moving the cases through the system. And I think, you know, Judge Albis set this in motion, and it's really done a good job. And my goal going forward is to not mess it up and to keep it going and make it, even if we have to make it, you know, any ways that we can make it more efficient. If anyone has any comments and things, and I'd be happy to address that.
We are going to do all those comments and questions from the public at the end, but thank you very much, and do not mess up what your predecessor did is always very good advice. So here's the next question. Director DiTunno, I understand you have some statistics for us. Would you kindly share them? And are we going to do that, Ashley, on the screen, or he's just going to? All right.
Thank you. Lieutenant.
Floor is yours.
Before I do that, I do want to speak briefly about the family relations counselors that are part of the Judicial Branch Court Support Services Division. Judge Albis and Judge Nana were talking about the work we do at the resolution plan date. And
can you move the microphone a little closer, because
I wanted to talk about the family relations counselors and the great work that they do. Family relations counselors are really unique to Connecticut. Other states do not have family relations counselors in family court to deal with the disputes that the parents bring. We are lucky. Our family relations counselors actually work in both the adult criminal court dealing with people arrested for domestic violence. So we're really versed in domestic violence issues. We deal with those cases each and every day at arraignment, but also we assess those cases in adult criminal court. We also have a huge role in the TRO, the restraining order process, 46B15. A family relations counselor is meeting with the respondent and the applicant in that process as well. So in terms of being grounded in domestic violence and coercive control, our family relations counselors really do bring a unique perspective to the work in the family court. Our family relations counselors this past calendar year did 12,500 RPDs. Over the course of the past 2 years, it was over 26,000 RPDs. So we are interacting with litigants attempting to resolve their disputes. When pathways was being discussed early on, a foreign concept to a lot of us, the deputy chief court administrator at the time, what she said to me resonated, and is that we need early intervention. That's really key to pathways and triage, is to work with the parties as early as possible so that we can get grounded in really what their issues are. And that really leads to early identification of issues. Our family relations counselors are really successful at getting agreements with parties, especially with self-represented litigants. But I think more the family relations counselor in the RPD is really assisting the parties in learning how to navigate a difficult system. It allows individuals that are in the RPD to really communicate for the first time. Hopefully, if it's a domestic violence situation, we're not interviewing them together or working with them together, but allows them to communicate about the dispute, what each side would like. And the family relations counselor is able to give recommendations to the parties with the hopes of resolving the entire situation that first court day. What we know from our statistics is about 30% of the cases that go to RPD, we're recommending a track A, which means little or no resources, with the goal of that court date, if there's a judge available, or a court date in the very near future, that case is going to judgment, and 30% of those cases are leaving the system as quickly as possible. The family relations counselor at the end of the RPD, we are working with the parties. If they have temporary agreements, we're helping them get those in front of a judge. If they need other services, family relations counselors and family services, we offer a wide array of direct services for people, from mediation, which is an alternative dispute resolution program, early intervention program, all the way up to comprehensive evaluations that Judge Albis and Judge Diana were talking about. All those services are free of charge. Obviously, the taxpayers pay our salaries, but in terms of additional cost, all what family services offers to the parties is free of additional charge. The family relations counselor also needs to predict accurately the resources necessary to resolve the parents or the litigants' dispute. And how we do that is we recommend a track to the judges of the Superior Court. And as Judge Diana said, sometimes they don't agree with our recommended track designations, but my hope is that that is the exception, not the rule. But family relations counselors are certainly recommending tracks. Again, 30% are A track, about 60%, 65% are B track, which is they need some resources. It could be a limited hearing, but it also could be an alternative dispute resolution process like mediation through family services or general case management, some of the things we offer. 5% go to a C track, which is usually a comprehensive evaluation. And that is going to be the track that really is going to lead to litigation and a lengthy trial, either on the whole divorce or if it's a custody situation, custody and access. Our family relations counselors are working and doing this weekly in court with the goal of helping parties resolve their issues. No other state, like I said, has a family relations counselor. Usually triage or this pathways approach is done on the papers. They look at filings, and from those filings, they decide the resources. Family services is a little different. We do that live with the parties. We're able to talk to them, and we're also able to understand their dispute and hopefully put them on the track that leads to some success. But in terms of 26,000 cases, if you think about 30% not moving on and getting in front of a judge within 30 to 45 days, that's a huge benefit for not only the litigants, but also the children.
Well, thank you so much for sharing those numbers. And I'll open up the floor to any of the panelists who want to answer this question. One common issue that we find in divorce and custody and visitation cases is violence. And at times there's a prevalence of coercive control. So I'm wondering if for the benefit of our audience, someone on this panel can share what is the distinction between domestic violence, domestic abuse, and coercive control? Megan, I think you got that.
I think I can do this. So I think it's important to understand that coercive control has actually been around a lot longer than maybe the term we've been using. So coercive control is a term that we've been using most recently, and obviously with the passage or the change in the definition of the law in Connecticut to include coercive control as a form of domestic violence. So it's a form of violence. It's actually a non-physical form of domestic violence. It needs to include a pattern of behavior over a period of time. It can be psychological in nature. It can be financial in nature. It can be emotional. You can, in the Connecticut statute, even threats to harming animals or children are involved in covered under the statute now. Prior to the law being updated, only physical forms of violence were able to be acted upon by the court. So I think it's important to understand, I think judges and other court personnel had seen coercive control or those patterns of behavior before the law was passed, but didn't have any kind of mechanism to address it. So under the statute, restraining order, you were now able to go in and request a restraining order for a non-physical pattern of behavior, and a judge could hear that and could issue that restraining order. So I think it's important for everybody to understand that these behaviors have been around for a very long time, for as long as humans have probably existed, because our patterns of behavior have not changed very much. So in Connecticut, the statute changed, so we were able to address it through court and through a restraining order process. So that, I think, is the biggest change. I don't know if any folks have questions on that, or if anybody wanted to add anything.
Yes, I would just add that, coercive control is a form of domestic violence, and it is now one of the ways in which someone can obtain a 46B-15 restraining order application from the family court. It is very nuanced and difficult to prove, and trying to assess those behaviors and present them to the court in a way that, meets the burden of proof can be quite challenging. And that's one of the challenges of presenting coercive control as a form of DV, but it's absolutely a part of DV that has been around for a long time. And I would say in Connecticut, we have a statute that defines domestic violence, and that was added to it. But often the terms domestic violence and domestic abuse are used interchangeably. What's important to note is that DV is really a range of behaviors that are harmful, and that harmful is harmful regardless of the definition. So yes, we have a statute, but we also have to be mindful of the behaviors that are occurring within each family dynamic and how those are impacting the parties and especially the children. It's really important to keep mindful that some of these harmful behaviors are stemming from personality disorders as well. And so understanding mental health and how that impacts the family is also an important part of the conversation. It's great that we have coercive control as kind of the newest addition to the statute, but it is very nuanced and complex and often hard to prove. And I don't know, Margot, if you want to add to that.
Just briefly, I will add that in working with individuals who are seeking restraining orders or who are in difficult situations, either in a custody case or a divorce case, it's sometimes hard for them to even understand what behaviors actually are considered coercive control. So to help out with that, I just want to list just a few of those behaviors. They could include things like isolating you from your friends or family, controlling what you eat, what you wear, who you spend time with, monitoring where you go, either by requiring you to share your location on your phone or putting a GPS monitor in your car or on your person without your knowledge. A big one that we see a lot is threatening to disclose information about you publicly through social media or through other sources. All of these behaviors and more that I haven't mentioned are types of coercive control that people sometimes don't recognize as domestic violence, but fortunately now the courts are recognizing them as such.
Judge Albis.
Just one thing I'd like to say is that in the context of restraining order hearings, we of course are limited to what the definition of domestic violence is. In a custody or visitation or divorce case, anything that would constitute domestic violence under that definition would also, in my view, and I think Judge Diana would agree, be relevant to many of the issues, but we're not so limited to that definition in those cases. For example, there might be a spouse who uses profanity and berates the other spouse, and maybe it doesn't rise to the level of domestic violence, but it might contribute to the cause of the breakdown of the marriage, which we are by statute to consider when we make orders on financial matters. It might contribute to our view of who is a more appropriate parent for these children. So there can be, I think, kinds of abuse that may not fit the precise definition that we be limited to in a restraining order that could be relevant in a divorce or custody or visitation proceeding.
We do have a question online. Someone asked, how many hours of training does every family relations counselor receive, specifically in coercive control, prior to working with the families? And do they assess every case for coercive control at the beginning of the process in order to choose the appropriate track?
So in terms of our yearly training, so before a family relations counselor even begins work in earnest, we have a 200-hour program. It's pre-service, and domestic violence is certainly trained, and our partners at CCADV do help in that training. We were very fortunate when the new law was passed. CCADV did train all the family relations counselors specifically on coercive control, and our friend Linda Belosi did training, which was very extensive and helpful to our family relations counselors as we started to understand. And I think Meghan's very correct. We've seen those behaviors in the cases that we've dealt with for a long time, but now that they were put into law, the training from CCADV was very helpful. So that was how we do that. So again, we have pre-service, then we have in-service. Our family relations counselors need to do in-service training each year, and many of those hours are around domestic violence. Fortunately for us, we have a great collaboration with CCADV. We work in the criminal court, family relations counselors in a unit alongside the family violence victim advocates. And we do many joint trainings around our risk assessments. They also participate in helping us on the criminal court side with those risk assessments and scoring those risk assessments. So very fortunate that we have that collaboration, and we do many joint trainings.
And I think that's a very nice segue into a question for Meghan Scanlon as the leader of CCADV. Tell us how successful you think the Pathways process has been in resolving these cases, and particularly those involving domestic violence.
Sure. I want to thank everybody for their participation today as well. So CCADV is and continues to be supportive of the Pathways program. We, for a number of reasons, all of which Judge Albis sort of covered in terms of resources, are dedicated to those cases that need additional resources. There's the ability to cut down and reduce any kind of litigation abuse that we see as a form of abuse amongst the population that we serve across the state. But then they're also able to get on a regular schedule. We know that a barrier for a lot of the people that we serve across the state is having to take time off of work or having unexpected court appearances, and that can be a dynamic of power and control from one party to the next. So we see that as a benefit of the program. And we also, have recognized that in the areas that Pathways has worked, we've gotten feedback from victims across the state, and this is anecdotal, I don't have any hard data, that it's worked really well. in their cases. For the areas that it hasn't worked that well, it has not worked well. So I think it's for the most part been positive. There's definitely some areas that we can work with the group to improve. I know there's been, for example, there has been some issues around timing. If a court date has been changed, there's been some issues with some of our clients across the state that might have needs around child support that they need to address, or visitation. And that can cause a little bit of a stressor when the date is delayed a little bit. To Judge Albis's point, there is the motion calendar to address that. But again, I think some of it is education, as Judge Diana talked about, and also the advocacy. And I think overall, like Joe said, we've done a really collaborative approach to training and education when it comes to the family, the family counselors that are in court. We do have civil advocates in some of our family courts, not all. We don't have the same robust program that we have on the criminal side with the family violence victim advocates on the civil side. So we don't have as many resources to be able to assist victims that we do on the criminal side. So that's obviously an area that we could certainly improve in terms of our services. But I think overall, where I think the areas to improve might stem from are more systemic for victims. I think there's obviously stigmatization still around identifying as a victim of domestic violence or a survivor. I think there's definitely some mixed advice that maybe attorneys give around whether to disclose that or not in court through this process. So I think that's something we could certainly talk through and try to address with attorneys. Joe did a good job of talking about how the family relations counselors definitely factor in, the safety planning of whether or not offender and a victim can be in the same room. I think for the most part, that consistently works well, but there's certainly been cases and outliers that hasn't necessarily worked out as well as we would have hoped. I think the good thing is we've had an open line of communication to be able to resolve some of those outliers that have happened. And the credit goes obviously to CCADV staff, as well as Joe and his team for working out some of those issues, as well as the folks here on this panel. And then I think, we talked a little bit, and I know Judge Diana addressed this, the need for more education. I think the need for more education, that's always something we're going to work to improve. We have really great, robust training with the family relations counselors, obviously, but we can certainly do more in terms of training, other court personnel, attorneys, and making sure that we're able to, even do some more trainings throughout our community partners on this program, but then also on the forms of domestic violence that the statute covers, and then the examples for folks to understand more. So I think overall, we feel fortunate in Connecticut to have this program. I know it's in its infancy, but there are other states that we work with in terms of our sister coalitions across the country that don't have anything like this, that have had to resort to other forms of addressing some of these higher conflict cases. And I do think that Connecticut is doing the right thing by having this program. But we're certainly, always willing to talk about ways to improve it in the future and to make sure that we center the victim experience and voice in those improvements.
Thank you, Megan. And I'm going to ask the folks from legal aid, both Greater Hartford and New Haven, to weigh in and tell us about the kinds of issues you are finding as your clients come into your organization looking for assistance with their cases. And is there any more guidance or resources needed to effectively represent your clients?
Sure. So first, let me say that one of the positives that really came out of this new pathways process is that now individuals who have orders of protection in place do have the option of appearing remotely before the court. And that is something that was not in place prior to pathways. And so I think that is certainly something that is another tool for victims to determine if it's within their safety plan to appear in person and face their abuser, or if it makes more sense for them to appear remotely for court. And so that has been an additional resource for victims that I think has been extremely beneficial under pathways. One of our, existing concerns, and again, pathways is still very new and we're all adapting, is really the ability to get into court more quickly. Because unfortunately in DV cases is where we see a lot of people resorting to self-help and engaging in behaviors that are harmful to both the parties and the children when they don't have access to the court as quickly. And in the older system, they would be able to get into court as often as 2 weeks after their their divorce case started, for example, or their custody case, and now they're waiting a little bit longer. And so the triage system is an effective system. However, I think our concerns that we've voiced to Judicial, and Judicial is fully aware of and understands our concerns, and we've been working closely with them to try to address that. And yes, this still is a work in progress. It is helpful when speaking to victims to make sure that they understand their options and their rights, and how quickly they can get into court is something that we assess with them as part of their safety plan. And so having the predictability and having the access to the court is really something that is our focus, both under the old system and the new, and that's not going to change. I think when we're working with clients who need to know, especially our clients who are indigent and often don't have the ability to just up and go. They don't have daycare. They don't, often have the money to just move to another place. So getting those PL orders for child support, alimony, exclusive use of the home, or just a parenting plan in place is really an integral part of their safety plan for both, again, the parties and the children, so that they're not resorting to self-help. And to the extent they could get into court sooner, I think that really provides a huge benefit. And so I know that the motion docket was a recent addition to pathways to allow for that to happen. And also the new statute that was implemented as well is another resource for victims to do that. Because without the child support or the alimony, especially in our cases where we're working with indigent individuals, they don't have the ability to sometimes be safer, to move somewhere else, to live independently from their abuser. And so having that access is crucial.
And I'll just add to what Enelsa has articulated, which I fully agree with. It is sometimes an issue for our clients to have to wait the 30 to 45 days to get into court for their RPD, even though it is possible and maybe even likely that they'll be able to get some initial orders put into place on the RPD date. There are certainly a lot of situations where our clients' documents are being withheld, or a vehicle is being withheld, or they're being cut off financially. So that 30 to 45 days where they're waiting to get into court is really crucial. So perhaps the motions docket would address that. Perhaps they could get onto the motions docket before the RPD, and that would be a great assistance. I don't know if this is necessarily an answer to your question, but I'm gonna add the one issue that our clients see frequently when they do get into court for their RPD or for any other proceeding, is that often, many of our clients need the use of the court interpreters. And our interpreters are amazing. I primarily practice in New Haven, but they are amazing, and they really try their best to be present for us, when we need them. And but sometimes we need them a lot and on several cases, and there's usually only there's often one person who's trying to juggle many cases on the docket. So of course, everybody has to be patient. Everybody has to wait their turn. There's a lot of people there, but for our clients, they do often spend a lot more time in court for that reason. So That's one of the challenges that they face when they come into court.
Thank you. We're going to have one more question. Oh, pardon me.
If I could just address a couple of points. One is that there's no reason a litigant couldn't file a motion before the RPD and file a request to have it put on the motion docket before the RPD. So if it's urgent, you don't have to wait. And I did do a sort of an informal survey of family presiding judges around the state in the middle of last year, just to ask when someone asks to be on the motion docket, how long does it take? And the vast majority of family court presiding judges reported that it's in the range of 2 to 4 weeks. So that can be done. On the interpreter issue, that certainly is an issue. One thing that the branch is doing to try to alleviate that is to increase the use of remote interpreters through specialized equipment that allows the interpreters to be in a central location, so they're not losing time traveling court to court and not being available. So hopefully, as that becomes more prevalent, the ease of getting an interpreter will increase.
All right. Well, we'll have, let's spend a couple of minutes on this question. If anyone has any suggestions about what the executive branch can do to increase the success of the pathway process or in diminishing the volume of domestic violence cases in the judicial branch.
I think as a state, we just need to be really mindful of how domestic violence is pervasive and often starts at such a young age. And violence is such an integral part of our culture, unfortunately, that it's really difficult. By the time folks come to us, by the time they get to an attorney or they get to court, it's often too late. And so really having a discussion about how to reduce violent behaviors is an important conversation that we all need to be having, not just, you know, the judges and the attorneys and clients, but as a state, and to really consider how we can reduce this at an earlier stage in life so that, you know, when parties are in family litigation, you know, we can put a Band-Aid on it, we can try to address the concerns, but at that point, it's already occurring and it's already a little difficult to navigate. So to really think about in advance how we can try to reduce that and how we can do our part so that it's not happening in the family courts is obviously an important conversation that we should be having. Unfortunately, you know, these cases get to a point where we're involved, and often our clients, they don't necessarily want a divorce, or they don't necessarily want their partner arrested and jailed. What they want is for the abuse to stop. But because that isn't really an option, they don't have the resources to help that happen, it's not happening. And so I can't tell you how often enough, you know, I'm meeting with clients and what they want is, well, can't I get a judge to order him to, you know, go to counseling or to get the help? Because that's what their focus is on, trying to keep their family intact and keep the unit together and to really get the help for their loved one. But when that isn't happening and we see the breakdown of the family, then unfortunately we're just trying to, at that point, really provide the best relief that we can. And it's a little bit late in the process. So I think trying to address that earlier on is really important.
If I could add, addition to early intervention with families, education and otherwise, the executive branch could help, I believe, by supporting and making more accessible, affordable housing, and by making public benefits more accessible to people. Often we see clients who can't leave because despite the domestic violence, they have nowhere to go. They can't afford other housing, and they don't have public benefits available to them for various reasons. So I think those are kind of more broad-based issues that can be
And
addressed.
we hear you, and that's why more housing is at the top of our agenda. We'll go to Meghan Scanlon, and then we'll go to you, Leo.
So I would echo some of those same issues, right? We could not have more, we need as much affordable, safe housing as possible. But one of the things, like, just to educate, so we do have, in terms of victim services, I think what I would say is, prioritizing victim services, in terms of it being a priority for the executive branch in terms of budgeting would resolve some of the issues that Enelsa brought up. We have community educators out there that are doing the work in the schools, that are trying to work on those preventative measures with young people, and working with them. It's not something that is funded. So we're scrapping together as much private philanthropy that will allow for that work, but certainly investing in preventative programming is something we would absolutely advocate for. But then you also have to invest in the victim services and in all of the other services that go into that, which is housing and food, making sure people are food secure, making sure that they have access to job training and employment. I did see the governor is going to take away the fees for some of the certifications, so that's a great first step. But I think as a state, we kind of have to ask ourselves, are we going to invest in the programs that victims and survivors need in order to be able to make an informed, safe decision for them and their family? Right now, they're choosing between who's going to pay the rent, and safety. So, and sometimes because that person can pay the rent, they're staying in that situation. So I think we're putting people in impossible situations. And unless we realign our priorities as a state in terms of investment, I don't think we're going to solve this cycle of violence.
Thank you, Judge Diana. And then we're gonna, I think, open up to the public.
I think that the executive branch could support, the policies as they have regarding, education, a living wage, health insurance, mental health treatment. Many people that I see have mental health issues that are untreated, undiagnosed. I see it evolve before me. The other party testifies to some of these behaviors. There's no medication, no treatment. So that's a big gap. The other huge gap that I see is when people are in these situations and, like Enelsa said, they don't want to destroy their family. They just want this to stop. One way it can stop is by having supervised visitations. And there's no program available. There's supervised visitation available privately at a fee. These people can't afford those fees. The cheapest rate, I think I heard, was $50 an hour, but it's more than people can afford. The average rate is over $100 an hour. And unless a family member is willing, which a lot of times they've already burned all those bridges, so there's no one else available. So there needs to be something to fill that gap, to allow a chance for the family to get through this hurdle and have a supervised visitation available. And I think that will go a long way, because you're either going to pay for it at the front end of it or at the back end of it through the criminal justice system. And I think this is a much better investment, a lot cheaper.
Thank you, Judge. Ashley, do we have questions?
Yes, we do have quite a bit. I will start with Rep. Osborne.
Thank you very much. Thank you, Lieutenant Governor, and good afternoon to Judge Albis and Judge Diana. I've practiced in front of you both, and I'm a practicing attorney in addition to being a state representative, and I practice primarily in Judge Diana's court. So I'll be really careful about what I'm saying to Judge Diana right now. But I'm primarily concerned with how the Pathways program works on that track C. When you do have a very high conflict case, those cases are ripe for parties with personality disorders and for coercive control to really run rampant, because there doesn't seem to be a system within Pathways, which, by the way, the Pathways program works very, very well for track A and really pretty well for track B. But it's those track C cases where the parties can get lost, where the financial control, where the financial coercion can really run rampant, where the party with the power or the knowledge can engage in all sorts of discovery abuse, whether that's discovery withholdings, so the knowledge isn't there, and people get starved into submission because they can't afford attorneys, because attorneys have to be able to make a living and practice as well. But I would love to see something developed within the Pathways program that was more hands-on for these Track C cases, so that there was an accountability and these emergencies didn't have an opportunity to arise. And I'd like to know, is there something as a legislator that I can do to support that type of solution for those Track C cases? If Judge Diana or Judge Albis could speak to, is there something in the current legislation that you feel could be beefed up? How can I help? I have my own ideas, but I want to know your ideas.
Judge Albis, do you want to try to address that?
I'll try. I think when you're talking about withholding information and discovery issues, that's usually got to do with financial issues. And we need to be mindful that there are longstanding practice rules that allow for exchange of information, require exchange of information, and have remedies if someone isn't disclosing what they should. One advantage of Pathways that I mentioned earlier was the appointment of a designated judge to a case from start to finish, because I think those kinds of issues are even more difficult when in the old days, when you go to short calendar time after time, and there could be a different judge every time you went who hadn't heard the story before and is starting fresh. So that was one thing that we're doing. And I think we still need to perfect that to make sure that every complex case gets a dedicated judge to try to limit any abuse along those lines. Unfortunately, preventing things before they happen, I'm not sure what the court could do to prevent a litigant from attempting some of those things. We have procedures to deal with them when they happen. And we do set a schedule for discovery early on, which is intended to make sure things get done when they were supposed to. There's a clear court order. That's the first step. But those difficult cases are unfortunately always going to be the most difficult. I'm not sure what could be done if Judge Diana has any ideas as a matter of a statute or even a rule to address what kind of takes on different forms in different cases. Judge Diana, do you have any ideas?
Well, there is something called a discovery special master. Discovery is the exchange of information between the parties. And there's certain, a practice book section which says you have to exchange this certain information. I see that it's been withheld a lot, and it results in a motion to compel. So one party files this motion, says, hey, provide me with this standard discovery. The other side does not provide it. So then the party asking for it files a motion to compel. And when that's granted and the party still doesn't comply with it, then a motion for contempt is filed, and then there's a hearing that's held. So a hearing is held regarding that, and if the party is found in contempt by clear and convincing evidence, the sanction is not only to turn over that, but it's a monetary sanction. So that's the system that we have now. If you know of a better way to deal with that, because it's a constant issue. Every day I spend time between lawyers and parties on discovery. And what happens is the case is set for a trial on a certain date. These standing orders are issued, scheduling orders regarding discovery is supposed to be exchanged. So on paper, it looks great. In practice, some people abuse the system, and that needs to be brought to the court's attention immediately. And frankly, you know, the contempt, and the court does have the ability on a contempt, if it's outrageous, to incarcerate someone. I mean, that's the most extreme remedy, but that is available. But I'd be interested to know what other suggestions that you have. And because even if a case is on a track C, it still has certain orders that are in place. So there still can be child support orders, parenting schedules. I think the situation the council is talking about is when parties are maybe trapped in the same residence, and it's this uncomfortable tension exists, and there's no way to get out of it, and everything is locked up because there's these automatic orders that say that, you know, whatever money we do have, you just can't go spend it. They have to be for these certain things. So I can see that there is a challenge in those situations.
I think that a lot of and just through you, Lieutenant Governor,
Yes.
a lot of the problems with that process, if you do have coercive control involved in that, is that everything you're talking about, Your Honor, costs money, and it costs a lot of money, and people run out of money, and then they don't have access to attorney's fees, and then they don't have access to counsel, and then all of a sudden they're giving in or they're going without. And those are the really thorny cases for me as a practitioner. And I'm going to noodle this, and I'd love to have some more conversations about how we can do that better. Thank you.
I think everybody is interested in that, Representative Osborne. So, Ashley, should we go to take some questions in the room?
So we do have quite a few online still that kind of keep in line with coercive control. So I would just prefer to kind of keep on that and then kind of go to the room if you.
Okay, so why don't we, we'll give them till 3:15
Yep.
on the coercive control, and then we're going to go directly to the room.
So a lot of the comments have been around coercive control. In line with that, does the court measure litigation abuse as an aspect of coercive control?
Judges,
I think that certainly can be one aspect of it. Without taking up more time than that, I think the answer is yes.
And I mean, I'm speaking for Joe here, but well, I guess I shouldn't, but as Joe talked about before, we CCADV work with the family relations counselors and train them on coercive control and other forms of domestic violence. So when you're talking about doing those evaluations, that is a factor. But I'll let you speak more to that.
You did a really nice job. Yeah, I think there's a lot of dynamics in play when we're working with parties, and that is certainly one of them. And I think that one of the worries that we had early on, and that's one of the reasons why we brought CCADV even before Pathways was even really fully launched. We brought CCADV at the table to talk about kind of the process and some of the issues and the concerns. So, you know, it's a difficult set of circumstances, but I agree with Judge Albis about it is certainly part of coercive control.
Ashley.
Yes, and another question we have is there any consideration being given to maintaining the same judge when a case extends over a long period of time? People are complaining that when a judge changed, perhaps that the case they have to start all over again.
That relates really to what I talked about before, the idea that in a track C case, the one where it appears there may be the most conflict, that the Pathways approach calls for a designated judge. Now, things can happen. Judges can retire. Judges can be reassigned to a different courthouse. So it's not foolproof, but that is the effort, and there is value to that we recognize. That's why we made it part of the process.
Can I just add to that as well? Not all cases are identified as track C initially that may ultimately become track C. So it's important that if you're in front of the court and your case started as a track A or B, and you feel like you need more court attention or you need a designated judge, that you raise that with the court and you let them know that potentially this case has gotten more complicated or more nuanced, or there is litigation abuse happening, and that potentially it needs to be redesignated because without raising those concerns, the court may not be aware. And so the initial family relations screen that was done may not be accurate as to what is currently happening in that case. And it may not have been, something that was prevalent in the beginning, or may not have been picked up on yet. And so things do change as the case progresses. It's important to continue to bring that to the court's attention.
Ashley.
I think we can open it up to the room now. So let's.
Great. So we're going to start with Trevor Crow. We'll go to you. I'm sorry, I don't know your name. And then to you. And then what we'll do is, and yes, you can go after the lady right here. And would you go to the chair first? So Trevor, if you would just go to and give your name and feel free to.
Is it on? There it goes. Trevor Crow, licensed marriage and family therapist. I'm also a Democratic candidate for District 36 State Senate. How do you tackle parental alienation? Because it is part of coercive control. And as a therapist, I've seen it certainly fall out in a divorce process.
Anybody want to tackle that softball question?
I mean, I think if that is a case that is before a family relations counselor, I would imagine that those are track C situations where there's probably going to be either a comprehensive evaluation by family services, or if the judge orders something that might be more akin to psychological evaluations or something like that. But it would certainly be something that would not be a track A or B case. I think that those would be the cases that would really utilize and require more court resources and time.
Do we have an education process for family counselors, judges, et cetera, on what to look for?
Relative to,
Parental alienation.
Well, I can speak as to judges, we do.
Okay.
And often this doesn't come up until the post-judgment part of the case,
Exactly.
which we haven't talked about at all. But
Mhm.
when a case is over and goes to judgment, it doesn't mean it's over. There can be motions after judgment to change custody orders, to change financial orders regarding alimony and child support. And that's where I've seen parental alienation come up more frequently. And the ultimate resource a judge has in a situation like that is to change custody from the parent who's found to be committing alienation to the other parent.
Mhm. Mhm.
So we're aware of it. It's a difficult situation, but that's the ultimate, in my view, the ultimate remedy for that. If presuming the other parent is appropriate, obviously, and then the child will be safe and sound with that parent.
Thank you.
All right, thank you. I want to make sure that everyone has the opportunity to ask their question, and please let us know who you are.
Good afternoon. My name is Elizabeth Holmes. I've spoken to many of you on the phone for the past 7 years. You say our system's better than any other. In 2018, a domestic violence expert wrote, "A court system that has either ignored, minimized, or misapprehended the nature of Mr. Markowitz, of the parties' relationship, giving Mr. Markowitz unlimited power to utilize its processes to continuously harass, threaten, and intimidate Ms. Holmes. That has continued until today." What are you doing for cases like mine that have fallen through the gaps? I know I'm not alone. I know there are hundreds of other moms facing similar things, from accusations of parental alienation, which I have faced, despite the fact that my son was harmed by his father, and that I have been harmed by his father, again, continuously. What's being done for those cases? Because for me, despite hundreds of phone calls with CCADV, Jerry Wild, and you yourself, Meghan, despite hours on the phone with many family relations officers, I believe Mr. DiTunno, you and I have had conversations, there is still not resolution. I'm still facing financial abuse. I'm still facing coercion, harassment, isolation, and there is no resolution. I've tried for 15 restraining orders in the state of Connecticut and have been denied every single time, including for being threatened with a firearm. So I just, again, this is another plea that you have all heard from me thousands of times. What can we do to change cases like mine and give women like me freedom finally from abuse?
So I think that is the topic of the conversation. And, I'm so sorry for everything that you are going through. So I think the answer is, if you have some ideas, this is an opportunity, and also talk to your legislators.
So I have been, I've called my flexor again, probably dozens of times. I have worked with Alex Kaiser. I worked with her on the coercive control law. My case is a big part of why that law was not about financial control, but about coercive control altogether. I've brought ideas around domestic violence evaluation similar to the one that I underwent in 2018 as part of like a track C process, so that cases like mine are looked at more scientifically and more with less emotion and more factually. There were aspects of domestic violence and coercive control that I never understood that I was experiencing, and that evaluation put science to what is mostly viewed emotion. I think some of the biggest problems that I see in these cases, because I now also consult on cases like mine, is a misdiagnosis. You see a mom that is traumatized, that is in crisis day in, day out, because we're continuously going through this process and being battered through the court system. And that is traumatizing. And instead of looking at us as traumatized victims, we're viewed as people with personality disorders or parental alienation. And my therapists have said for years, my CPTSD is a direct result of the abuse that I have faced by my abuser and my son's father and this court system. So what can be done to really mitigate those misdiagnoses, that lack of knowledge that's happening? I know that there was some education that came out of the coercive control law, but again, it's not enough. I am living proof that it is not enough. My son's father was just arrested last year in the court system for threatening a clerk. He still maintains full custody of our child despite having that outburst, despite not being a safe parent. And my son continues to advocate for himself with me and with others that he is not a safe parent. And yet still it has been maintained over and over and over and over again that he retains custody purely because of this mental health allegation that doesn't exist, right? I've been through evaluations, I've been through psych evaluations. There isn't a mental health issue on my end. Again, it's a coercive control issue, but when you get into the court system and you're traumatized and you're in crisis, because again, you're in this court system for the 100th time and God knows how long, and you're dealing with someone who has followed you to the court system, that is following you around the court itself, you know, it doesn't put you in the best position to represent yourself appropriately, right? And so you end up facing this bias and this stigma that you're just mentally ill and you're not a safe parent, when in reality, you're a traumatized person in crisis that deserves safety, right? So what can we do to really make sure that our family relations officers have this knowledge, have this understanding? Because I've worked with experts that have tried, right? David Mendel, Lundy Bancroft, Kathy Jones, and they don't get very far, right? And I've seen that within the judicial or within the juvenile system with David Mendel. DCF does not follow the policies that David Mendel outlined. That's very apparent in my case, and as well, he has documented that with the state. But then we're also seeing it in family and criminal, where we're seeing victims dismissed so often who deserve safety, right? And no matter how loud they argue for themselves, how loud they advocate for themselves, how often they go to organizations like CCADV, we're still falling through the cracks.
I appreciate your coming. Thank you so much for your courage. And I want to make sure, because we have 10 minutes left,
Yep.
to make sure we hear the other two individuals who expressed interest.
Of course, I just would love to hear from the judges, what can we do to ensure that there is no more gaps to fall through?
Judge, do either of you want to?
We really can't comment on individual cases. I don't know
I'm
your
not looking
case.
for comments on
excuse me.
individual cases. Thank
Well,
you.
I've described the process that we've implemented that is in large part was implemented because of issues like those that you raise. No process is perfect. We get training. We'll get more training. I really can't tell you what can be done in a particular case or particular type of case that we haven't provided for.
Then I think what we might want to be offering up, not to sound rude, is maybe there needs to be more work done, and we need to be talking and hearing from victims that are experiencing this. I can't tell you how many have tried to have their voices heard in spaces like this. Connecticut Protective Moms is a great example. They have been pretty silenced, and I understand why. They're frustrated. I'm frustrated. I have made thousands and thousands and thousands of phone calls. My domestic violence evaluation has been sent to every state representative and senator for the past 7 years. 7 years of standing on every mountaintop and being ignored. It takes a lot to keep doing it. And victims need to be heard. It's not appropriate to continue to allow cases like mine to go on year after year after year after year. And they have. And I know I'm not alone. I know there are thousands of mothers that face the exact same problems that I do, to the point where I can predict how quickly a mother will be put on supervised visitation for acknowledging domestic violence. I can predict that that'll take 3 to 6 months based off of judges or a family relations officer's behavior. It's completely inappropriate, right? And so I want to vocalize and advocate that you need to be hearing from victims like me. You need to include us at the table. CCADV is a great organization for many of those reasons. Jerry Wild picks up my calls so many times and has implemented things and brought my concerns to the table, but we need to be sitting at the same table. There needs to be room for us at the table. We are the bottom of the barrel that is falling through the gaps, that is facing those problems day in, day out, and it's completely inappropriate. We are a first world country and I don't get to have the job I want to have because he'll abuse me. I don't get to live where I want to live because he'll abuse me. And I'm 7 years later separated from my son's father, and I'm still concerned with these things, and I still face consequences for everything that I do. So I very strongly urge you to bring us to the table. And there are plenty of us that have tried over the years and have been silenced, and it's enough is enough at this point. Thank you.
Thank you.
Hi.
Hi.
Good afternoon. My name is Ashley Fawn, and I'm president and co-founder of a grassroots anti-child trafficking nonprofit called We Are One Inc. But I'm actually here today because I'm in the early stages of what was just described. I was advocating for other people in family court, but I ignored my own needs of my child because I was fearful of more domestic abuse through the court system. And I'm currently experiencing that in New Haven court. My daughter's father struggles with addiction. I was granted an emergency order of custody in November of last year. And then I was retaliated against by his parents and their corrupt attorney, intimidated outside of court. I have an autoimmune disorder and I'm getting sick, and I cannot advocate for my victims or continue my advocacy work because the reason I started everything was to protect children, and I can't protect my own child from family court. I was a self-represented party last Thursday against my daughter's paternal grandparents, who very vocally, I think Margot saw, committed a good amount of perjury and tried to make me the mentally ill one when their son was nodding out in the corner of the courtroom, and their attorney was named in the restraining order hearings that I didn't get to be heard because of a technicality, because I didn't have money for an attorney. They lost grandparent visitation rights. They tried to remove my First Amendment rights, or not First Amendment, my constitutional right as a mother to determine who molds my daughter's moral compass. And unfortunately, I don't want her to be associated with criminals like her grandparents and her father. But after they lost that, they were then granted access to my daughter, where they groom her against me and teach my daughter to commit domestic abuse towards me. So I was able to, I don't want to say I was able, my daughter's father filed a contempt citation because I cut off access in December. I did that to protect my daughter's mental health. She struggles from a similar learning disability as me, and she has a sensory photographic memory, so trauma is difficult for people like us. He filed that contempt citation after grandparents committed perjury and were denied visitation. The judge then allowed them to attend the parenting time of the core domestic abuser, which is my daughter's father, who still has rights while we're in this Plan B track. So what I just saw really scared me, because I almost put my history of PTSD on the record. And I will say that because I'm a public speaker for domestic violence. I was a previous survivor of strangulation about 7 years ago. So I was right in avoiding the court, because I am now a current victim of domestic abuse again. And I can't protect my daughter from now becoming a domestic abuser, because she has court-ordered visitation every Monday and Thursday, where the team of domestic abusers, my daughter's father, Joseph Gardiano, his father, Vincent Gardiano, and his nurse grandmother, or her nurse grandmother, Linda Gardiano, are allowed 6 hours of access to groom my own daughter against me. What can I do?
So I think we have an issue of, certainly the judges aren't able to comment, right? And so, we are, the rest of us are taking in your situation and, we are very empathetic. Thank you for coming and, letting judges know what you go through and our advocacy organizations and, legal assistance know. And, we wish you well, and we will do what we can to make the system better for everyone. And that's why we're here. So we appreciate your coming.
Great. Thank you.
Thank you for what you do.
Good afternoon. My name is Margaret Sullivan. I was a high school teacher in the state of Connecticut for over 25 years until my ex-husband during mid-trial decided to call my employer about, basically he shared ex parte orders with them and I ended up losing my job. In this court, the question I really had for today, and actually this goes to Ms. Holmes, some of the, I was listening to her and it's almost my exact same story. It's been, today will be 1,574 days since I've had an overnight visit with my children. And during a forensic report, it was found that I caused no emotional or physical abuse to them. So I don't understand how full custody can be awarded elsewhere. A couple of suggestions that I had for just listening to the questions that you had raised, Lieutenant Governor. I think there needs to be more accountability at the judicial level. There's a lot of great things. I mean, I've been pro se for the last 4.5 years. So I've, and being an English teacher, I think helped me navigate the process. I've been working as a layperson, helping so many people, so many moms with filing motions or just editing them. I'm not a lawyer. I always tell them I'm not a lawyer. This is my experience. That's all I need is to, you know, get cited for practice, even though I think I deserve an honorary JD at this point. But I've argued to the Supreme Court. Actually, on December 18th, I argued before the Supreme Court in Connecticut, and hopefully it will work. I've reversed 2 opinions at the appellate level. My third one was a review on bank, and the Supreme Court scooped it up because it's the first time the issue's been heard in Connecticut. But I think one of the issues you'd asked, especially with domestic violence, there has 2 things. The first thing, and I think it was alluded to because it did happen to me, don't bring up domestic violence in your divorce. Just go through the process, get out of it. It'll go away. Like, let's just get you guys separated is sort of the advice at least I was given. And I've heard from other moms, because if you bring up domestic violence after 10 years of marriage, why are you suddenly bringing it up during the divorce? And the question is, does it create a sense, you know, so I would just ask the judges, I know I'm not asking you to answer this question, but to reflect on the fact, does bias come into play when domestic violence is brought up for the first time? And ladies, I think, you know, for the work you do, it's hard. I mean, it's like, we don't know where to go. You know, it's like we're relying on the situation. What I do, just take my kids and leave. And then what does that mean? Like, I can't all of a sudden daycare or whatever. There's a lot of issues that come up. So I think if accusations of domestic violence are being made, I think one thing the courts can do is hold people accountable in one of 2 ways. These are just my suggestions, because mental health is an issue. So maybe someone is, you know, domestically violent because of their own mental health issues. Well, then, you know what? They need to be ordered into a program in order to get the help that they need before they have access to their children. If the accusation is found to be false, then that person needs to be held accountable for making a false accusation, not just, a slap on the wrist or ignore it, or that person doesn't get custody, because the 14th Amendment does guarantee us the right to be parents. Even if you're in jail, so I think murder is the only crime that there's statutes on the books that say, parents can still receive see their kids, even if they're in jail. And that you figure is the worst case scenario. But for someone like me I haven't talked to my daughter since 2020 because her father won't allow it. And that was based on a judge's order. So I think there needs to be accountability if abuse accusations are being made, especially at Track C. If you're going to carry it all the way through there, whether it's ordered mental health treatment or if it's found that you've domestically abused a child, that person needs to be arrested for that domestic abuse if you're going to change custody and visitation orders. The other suggestion, the judges had indicated that there is training. They have domestic violence training and they've had coercive control training. I've court watched enough all over this state for the last 4 years. That's what I don't have kids. I court watch. There needs to be more training for the judges if they're going to be the ones making decisions about custody and they say, oh, well, you have a personality disorder, so we're going to give the child to the abuser. Wait a minute. Are judges aware of the physical signs and the symptoms that women I'm going to say women in general. I know this is, it applies to both genders, but it's more common with women. That some of our craziness is because of the trauma that we're experiencing. It's not I'm an example. I'm 54 years old. It wasn't until 2021 that all of a sudden someone decided that I was suffering from childhood trauma and needed help. I lasted 25 years as an English teacher, raised 2 kids till they were about 10 and 11. And then all of a sudden I have mental health issues. You don't think that might have been tied to the abuse that I experienced at home and the trauma of having to be self-repped. And, being a crappy attorney at the beginning, it takes a while to learn the process. So I think just judges being trained into recognizing like where the similarities lie in what trauma looks like and what personality disorders might look like, and really those nuanced distinctions that can be made so that when judgments are being made about families, better decisions can be made.
Thank you so much. You make some very powerful points. We appreciate it. And congratulations on those court cases that you won to get to the Supreme Court. And now we're all curious as to what's going to happen. So let us know.
Hopefully by March, we'll find out. That's when, they seem to take 3 months.
Go ahead, Megan. You wanted to say something?
Yeah. No, I thank you very much for sharing, and obviously thank Elizabeth and others for sharing. And the one thing I wanted to mention, and it's somewhat relevant, because what I'm hearing a theme throughout the folks that have spoken, which, thank you for sharing your stories. I know it's very difficult to get up in a room full of somewhat strangers and share some of your most traumatic and intimate experiences. So I do want to sort of just honor that and uplift the folks that have done that today. I think part of this is not enough access to legal representation is what I was sort of hearing a theme throughout each individual story. And that is something that we CCADV know is an issue. There's obviously income-based representation, and then there's those that can afford representation, and there's this gap of folks in the middle. And we don't have a solution to this problem, but we do have 2 programs that I just wanted to put out there for folks in case they didn't know about them, which is our Family Law Legal Consult program. It is specifically for individuals that do find themselves in this gap in terms of the resource issue that they're having. They don't qualify for maybe legal aid or other legal services, but they also can't afford an attorney at a regular rate. So we do have that program available. You can certainly see me after, or Shauna, who's here, and Rhonda Morrow, actually, who I think is online, runs that program for us. So we can certainly talk to folks about if they might be interested. It's a free legal consult with one of our contracted attorneys that practices in the state. And then the other is the pro bono restraining order project that we have running throughout the state in various courts. It certainly might be something that might be beyond the folks in this room already, but for those that might be just starting this process, we do have the ability to represent at no cost individuals that might be seeking a restraining order, specifically around civil court and some of the coercive control that's been talked about here. And then lastly, and to your point about not knowing where to go, part of what CCADV does is we have 18 sites across the state. So we do have a robust team of nonprofits, of member agencies across the state that do have services from counseling to criminal advocates. You heard Joe talk about that we do have criminal court advocates in all the criminal courts. We don't have the same level of representation in our civil and family courts, unfortunately, but something we are working on. We have services for children, we have housing, we have shelter. Paula's here representing our New Haven area at the moment. So we do have over 400 advocates across the state that are very ready and willing to work with all of those individuals that may need help. So I don't want folks to leave here thinking that they have to do this all alone. And obviously our partners at Greater Hartford Legal Aid and New Haven Legal Assistance are always, here and a resource as well for those that can take advantage of those programs. So I just wanted to try to end on there are definitely ways to get help out there in the state of Connecticut. And if you do need those services, we can certainly stay after and talk about if you might be interested.
Wonderful. Thank you for helping us end on a positive note. And I want to thank all our amazing panelists who have joined us. And I want to thank all the people who watched and participated online. Thank you so much.